We have some breaking news right now from the Supreme Court that we need to bring in. We're just getting a decision having to do with transgender care for minors. Specifically, the Supreme Court upholding a Tennessee law restricting gender-affirming care for those minors. I want to get right to MSNBC's legal correspondent Lisa Rubin and Leah Littman, the University of Michigan professor of law and author of Lawless. Lisa, you've been looking over this decision. What can you tell us?
Well, Anna, I think the first and most important thing is the word restricts, because it's not a strict prohibition, and that was important to how the court decided this case. The law in Tennessee that restricts gender-affirming care to transgender minors allows the provision of transgender care in certain circumstances, such as when a minor has a congenital defect or a medical condition. What the court is saying here, however, is that the state has a legitimate reason for imposing this law, and that this law, because it classifies, because it prohibits or restricts this gender-affirming care to transgender individuals regardless of their biological sex, it would be the same if you were biologically male or biologically female, that it is not deserving of what the court would call heightened scrutiny on the basis of sex. Now, you may be remembering, as I'm sure Leah does better than I do, that there is a Supreme Court case from a couple of terms ago called Bostock that has to do with discrimination on the basis of not only sexual orientation, but gender identity in the workplace. That's a decision based on Title VII, a statute. And the court here saying, in somewhat tortured logic, that doesn't apply here. We decline to take up the issue of whether we have to extend the logic of that employment discrimination case to a situation in which we are talking about the constitutional protections available to transgender youth, even though in an employment discrimination context, we have decided that the phrase "because of sex" protects people on the basis of their gender identity. We're not going to do so in the context of thinking about what the Equal Protection Clause necessarily provides to transgender youth. So you see the three liberals here really taking issue with that. In particular, Justice Kagan saying she's not sure how that test would come out, but she thinks that the kids here who have sued and their parents deserve that heightened scrutiny that the court usually gives to sex-based classifications, and here that the court is refusing to apply to Tennessee's law.
And so, Leah, bottom line, if you are a transgender minor right now in the U.S. seeking gender-affirming care, what does this decision mean for you?
Unfortunately, this decision opens up a pathway for states to restrict gender-affirming care for transgender minors, in addition to concluding that this law does not discriminate on the basis of sex and trigger heightened careful scrutiny for that reason. The court also said that a law restricting gender-affirming care, so treatment for gender dysphoria, does not even discriminate on the basis of gender identity, does not discriminate against trans individuals as trans individuals. I think that portion of the opinion is alarming because in order to reach it, the court had to rely on some very outdated equal protection cases that said state laws that discriminate against pregnant individuals don't discriminate on the basis of sex, because even though the group harmed includes only women in that case, and here includes only transgender individuals, the group of individuals who can still obtain gender-affirming care for other reasons, like the congenital diseases that Lisa mentioned, includes both trans and non-trans individuals. And the concern with that logic is it allows states to enact laws that burden only the transgender community and seems to invite them to create more of those laws.
And so Lisa touched on this 2020 ruling that seemed to go the other direction, right? And it was actually penned by Justice Gorsuch, and it was a 6-3 decision. So there were not just Justice Gorsuch, but other conservative members of the court who had ruled in this case. And it was concluding that the federal law that bars sex discrimination in employment protected transgender and gay people. So why do you think this situation is different in the justice's eyes?
So I think the justices concluded that that decision was about interpreting a statute that Congress had created a particular standard for establishing sex discrimination that encompassed discrimination on the basis of gender identity. Here, they're saying the Constitution's guarantee of equal protection is not implicated when a state restricts health care for transgender individuals, at least transgender minors. And so they are limiting Bostock to a case about a federal statute. They also say that concern the area of employment, which seems to suggest that they might not be inclined to extend Bostock to other federal laws that prohibit discrimination on the basis of sex, such as laws that prohibit discrimination in the area of healthcare, for example.
So, Lisa, more than 20 states have enacted similar laws as Tennessee's law. What does this mean? Does this ruling now apply to each of those states?
I think states that have similar laws to Tennessee, to the extent that they offer a carve-out on the basis of medical conditions, and that carve-out, as Leah pointed out, can apply to both trans and non-trans youth, this case essentially gives them a permission structure, right? You don't have the absolute certainty that a case involving one of these other statutes would turn out exactly the same way if the text is not identical. But for the most part, these states can take comfort in today's ruling that they can ban gender-affirming care for transgender youth and not trigger the sort of heightened test that the Supreme Court traditionally applies to sex-based classifications. The one other thing that is alarming to me, Anna, about this decision is that, the Equal Protection Clause, unlike Title VII, doesn't contain the word sex anywhere in it. The court had to wrestle in the Bostock decision with a statute that plainly prohibits discrimination because of sex, right? You can't wish that out of the statute. But where equal protection is concerned, the words sex and gender don't appear anywhere. And we have seen again and again from the court in its current composition sort of a failure to extend the Equal Protection Clause to contexts that plainly look to people with common sense, as if they involve gender or sex-based discrimination. The abortion context is another one of these, where abortion rights advocates have for years tried to get the court to look at abortion restrictions in the context of sex discrimination, and that's something that this court has refused to do, saying it's really not about gender-based discrimination. Again, here, similarly, the text of the 14th Amendment sort of allows them to kind of divorce themselves from it and gives them the out to say they're not going to use a law like this to trigger the more exacting, precise examination of whether a law like this is justified by the scientific evidence and whether the state has a compelling interest in regulating health care to transgender youth. Instead, they apply what's called a rational basis test, which is sort of the lowest level scrutiny that the court will apply to something that's alleged to be discriminatory. And all they have to have is sort of, a reasonable interest in it. It's not a very exacting standard, and it's one that most state-based regulations and laws can very easily meet.